Case of illegal absorption of public deposits. A total fund of RMB 55 million was illegally absorbed. The amount involved falls under the category of an extraordinarily huge amount. How were the above funds utilized? The defendant A, in this case, is the actual person in charge of a private enterprise. The enterprise encountered capital shortages in the course of its business operation. He entered into loan contracts with investors as a means to raise funds. He actually absorbed 55 million RMB in funds. How were such funds allocated? The funds were mainly used for three purposes. First, payment of high interest to investors. Second, salaries and commissions payable to the company's employees. Third, a portion of the funds was invested in external projects. When the case was uncovered, the enterprise failed to repay matured funds to investors. An audit confirmed that outstanding unredeemed fund amounted to 21 million RMB. The procuratorial authority held the view that defendant A illegally absorbed public deposits, which disrupted the financial order, and the amount involved was extraordinarily huge. He shall be subject to criminal liability for the crime of illegal absorption of public deposits. Meanwhile, the procuratorate identified that defendant a constituted voluntary surrender, which may entitle him to a lighter or mitigated punishment. During court debate, the court summarized two core disputed focal points. First, whether the defendant's acts constitute the crime of illegal absorption of public deposits. Second, whether the refund of the funds involved in this case was completed before or after the institution of public prosecution. With regard to the first issue concerning the establishment of the criminal charge, defendant A raised funds by executing loan contracts and raised capital from unspecified members of the public. The company did not possess legal qualifications to absorb public savings. Such acts satisfy all constitutive elements of the crime of illegal absorption of public deposits. Senior attorney Lixiaohua acted as the first defense counsel and raised no substantive objection to the charged criminal offense. Second, the determination of the timing of fund refund and compensation, which served as the key breakthrough to obtain exemption from criminal punishment in this case. Pursuant to Article 6 of the Judicial Interpretation of the Supreme People's Court on several issues concerning the specific application of law in the trial of criminal cases involving illegal fundraising, where public deposits are illegally or disguisedly absorbed, and such funds are mainly used for normal production and business operations, and all absorbed funds are fully refunded prior to the institution of public prosecution, the illegally raised funds shall be fully returned. The offender may be exempted from criminal punishment. The first defense counsel argued that the defendant had fully refunded the entire outstanding fund of RMB 21 million before public prosecution was instituted. The full refund of the involved funds was fully completed before the procuratorial organ transferred the case to the People's Court for prosecution. This satisfies the statutory prerequisite of fully refunding absorbed funds prior to public prosecution. The defense strategy of this case was formulated around three dimensions. The first dimension, the defendant has the mitigating circumstance of voluntary surrender, which carries statutory leniency effect. After being brought to justice, the defendant truthfully confessed his conduct and the main criminal facts. A defendant's argument over the legal nature of his conduct shall not negate the finding of voluntary surrender. In accordance with the provisions of the judicial interpretation issued by the Supreme People's Court, a defendant's disagreement with the legal characterization of his conduct does not affect the establishment of voluntary surrender. The first defense counsel held that the defendant's conduct constitutes voluntary surrender, and he shall be given lenient punishment, which laid a procedural foundation for the subsequent application of exemption from criminal punishment. Article 67 of the criminal law stipulates that offenders with minor criminal circumstances may be exempted from punishment. The second dimension, the defendant's criminal methods and the corresponding social harmfulness. The first defense counsel submitted that defendant A's criminal methods and subjective malignancy were moderate. All funds obtained through criminal acts were used for repayment of principal and interest to investors, salaries and commissions of company staff, external investment and other normal business purposes, rather than personal squandering or illegal possession. This complies with the judicial interpretation of the Supreme People's Court, specifically the exemption condition that funds are mainly used for normal production and business operations, and is consistent with the evaluation standard of minor circumstances with trivial social harm. The third argument, the timing of the refund of the RMB 21 million involved funds. This point required precise legal argumentation. the first defense counsel took the refund timeline as the core disputed issue. As for fund repayment prior to public prosecution constitutes the core statutory element for exemption from criminal punishment, the defense counsel presented evidence to the court, proving that such funds shall be deemed fully refunded before the procuratorial authority filed the prosecution. Such full repayment minimized damage inflicted on the financial order and fully compensated investors for their principal losses. This line of argument directly addressed the second disputed focal point summarized by the court. This factor is decisive for whether exemption from criminal punishment can apply to this case. Holding of the court after trial, the accusation filed by the procuratorial authority that defendant A illegally absorbed public deposits disrupted the financial order with a huge amount of funds involved, thereby constituting the crime of illegal absorption of public deposits, is supported by clear criminal facts and sufficient credible evidence, and the charged criminal offense is established. The relevant defense arguments raised by the first defense counsel are legally grounded and supported by facts, and this court hereby accepts all such arguments. Defendant A's criminal circumstances are minor, with relatively low social harmfulness, and criminal punishment is unnecessary, so he may be exempted from criminal punishment in accordance with law. On the foregoing basis, the court rendered the following judgment. Defendant A is convicted of the crime of illegal absorption of public deposits and exempted from criminal punishment. This judgment reflects judicial value on three levels. First, the precise application of the criminal policy of tempering severity with leniency. Second, strict adherence to the statutory element of full refund prior to prosecution. Third, the decisive value of professional defense counsel specializing in commercial crime cases. In this case, defendant A faced an accusation involving RMB 55 million. The crime of illegal absorption of public deposits, yet ultimately obtained an exemption from criminal punishment. This fully demonstrates the professional competence of defense attorneys handling commercial criminal cases, and embodies the targeted implementation of China's criminal policy of balancing leniency and severity in individual cases. Nevertheless, we must clearly recognize that successful post-offense defense in individual commercial crime cases cannot replace proactive compliance risk prevention in advance. In the era of digital economy, enterprises' prevention and control of commercial criminal risks cannot merely rely on retaining professional criminal defense attorneys after legal risks arise to conduct post hoc defense work. Instead, enterprises shall adopt high-tech tools to establish a compliance-oriented early warning and risk prevention mechanism. Shanghai Lixiaohua law firm adheres to an innovative legal service model guided by party building and empowered by high technology, and provides intelligent compliance products to empower enterprises to take initiative in risk prevention and control, which supplies private enterprises engaged in compliant operation with a systematic solution, shifting from post-incident crisis disposal to pre-incident risk prevention.